rights of these Native peoples were not secured until the 1960s, 40 years after the 19th Amendment secured the right to vote for some women. The League is committed to protecting equal access to voting and resisting efforts to disenfranchise. Today, we will be learning about Held v. Montana, Montana's climate change case and why it matters. We're so excited to welcome Cathy Whitlock and Susan Dana. Cathy Whitlock is a Regents Professor Emerita of Earth Sciences at Montana State University. She is nationally and internationally recognized for her research and leadership activities in climate change and environmental science. In addition to her scientific publications, Dr. Whitlock is lead author of the Montana and Greater Yellowstone Climate Assessments, which describe the impacts of past and future climate change in the region. Dr. Whitlock has received numerous awards and honors from professional societies and organizations. And in 2018, she became the first person from a Montana university to be elected to the National Academy of Sciences. Susan Dana is an attorney and professor emerita of business law at MSU. During her 25-year career at MSU, she taught a variety of law-related courses in the Honors College and the Jake Jabs College of Business and Entrepreneurship, where she also served as Associate Dean and Interim Dean. She has recently taught Osher Lifelong Learning Institute at MSU courses on both the First Amendment and the law of privacy, and authors a blog on constitutional law issues. She holds a JD from Stanford Law School. We're asking you to please hold your questions. Just put them in the chat as they come up so that you don't forget them. And then at the end of this presentation, we'll have a question and answer portion where I'll read the questions from the chat. And if we have time, we'll also allow people to just raise their hand and ask any questions that they have. Cathy and Dana, thank you so much for your time.
Thanks. I'll get this going here.
So Cathy's going to control the slides here, and I'll just do a quick introduction to what we're going to cover. So I'll give you a quick background to the trial and to the Held versus Montana trial. Then Cathy, who was an expert witness in the case, will talk about the factual findings. And then I'll come back, talk about the legal implications, and then we will talk about where we go from here. So for the legal background, the case rests on some unique provisions in the Montana Constitution. Cathy, if you can show that Montana Constitution slide.
Yeah, just a second.
Got that?
There.
There we go. Thank you. So as you probably all know, the Montana Constitution has several provisions that are, there are not very many states in the country that have similar provisions. For purposes of this case, the key one is this first one, that we all have inalienable rights, including the right to a clean and healthful environment. The Constitution also says, and I really like this one, the state and each person shall maintain and improve a clean and healthful environment for present and future generations. And that's key to this case. So prior to 2011, Cathy, if we go to the next slide, that'd be great. Prior to 2011, in Montana, state agencies calculated greenhouse gas emissions and climate impacts in evaluating fossil fuel projects under the Montana Environmental Protection Act. But in 2011, our legislature passed a law that amended the MEPA, Montana Environmental Protection Act, as you see here, to prohibit state agencies from considering in their permitting reviews actual or potential impacts that are regional, national, or global in nature. That was interpreted for a long time to mean that the state agencies could not evaluate greenhouse gas emissions and their impacts on climate change. But in April of last year, State Judge Michael Moses stopped the permitting of the new natural gas power plant in Laurel because the DEQ, Department of Environmental Quality, had not considered the impact of the resulting emissions of greenhouse gases in Montana. So he looked at that 2011 law and said, well, that only talks about impacts that are regional, national, or global in nature. It doesn't talk about Montana. Therefore, the DEQ should be considering greenhouse gases impacts in Montana. Well, so that was just last April of 2023, while the legislature was in session. And you may recall that ruling alarmed some state legislators who introduced and passed a bill just about a week later that revised the 2011 statute, as you see here, into the 2023 law, was much more explicit and said specifically that agencies could not evaluate greenhouse gas emissions and corresponding impacts to the climate in the state or beyond its borders. So that very explicitly was a prohibition on the state ever considering greenhouse gas impacts. In the meantime, back in 2020, 16 young plaintiffs had sued the state, the governor, and several state agencies over the 2011 law on grounds that the prohibition on considering greenhouse gases violated the Montana constitutional guarantee of a clean and healthful environment, as well as several other constitutional provisions and some statutes. So I'll turn it over to Cathy to talk about the trial.
Yeah, thanks. So I got involved in the trial because I was the lead author on the 2017 Montana climate assessment, and that, was really critical in the youth plaintiff's case. And then after that, we produced a follow-up report on climate change and human health in Montana, and more recently, an assessment of climate change in Greater Yellowstone, the Greater Yellowstone ecosystem. These assessments are somewhat unique because of the focus on smaller regions than the country or the region. And assessments are really an effort to take the best scientific information available at the time and put it into words that hopefully most people can understand. So you're taking this huge heap of scientific literature and trying to synthesize it and make it available to the public and to decision makers. And I should also add that assessments aren't written by one person or two people. They're written by a whole team of people, and we try to get as many different sectors involved in these assessments as possible. So the Montana assessment was written by people at Montana State University, University of Montana, by federal and state agencies. We involved people from the tribes, and they wrote sections. For-profits and nonprofits were involved as well. So it's a big operation. It takes a couple of years to do and get the document reviewed at the national level. It's really a team effort. I wanted to walk you through the timeline of the case, and I'm not a lawyer, so bear with me. I'll do this as best I can. But a lot of the things that came up during the trial, of course, now are part of the appeal from to the Supreme Court by the state. So in 2020, let's see, the 16 Montana youth ages 2 to 18 at the time filed a case stating that their constitutional rights were being violated by the state of Montana. And almost immediately, the defendants moved to dismiss this, arguing that the plaintiffs lacked standing. The present claim was barred by prudential limitation, and that the plaintiffs hadn't really explored all of the possible administrative remedies for their grievance. In February of 2021, the attorneys for the youth plaintiffs presented oral arguments on the state's motion to dismiss. And then in August of 2021, the judge ruled that the youth plaintiffs could proceed to trial and denied the state's attempts to prevent the case from going forward. Although the judge denied the plaintiffs' request for to have the court develop a remedial plan. So then we're into 2022. The Attorney General requested that the Montana Supreme Court take supervisory control of the case away from Judge Seeley in the district court and to issue a stay blocking discovery efforts. A few days later, the Supreme Court denied that state's writ of supervisory control and the related motion to stay the blocking of the discovery. But Judge Seeley did grant the state additional time to prepare for the trial and set a date for the first children's climate trial in U.S. history in October of she set the date in October of 2022. Now, when I was asked to be part of the trial in the case, I didn't think it would be a big obligation of time, but it turned out that it took a long time. Part of this was preparing expert testimony, responding to and rebutting reports from the defendant's experts, and then just going through the depositions itself. And literally, I wrote dozens of pages with my colleague Steve Running at University of Montana. I'm sure he's well known to many people listening. Yeah, we wrote dozens of pages going back and forth in response to what the defendants were claiming. So it got even more interesting as the trial date approached. In May of 2023, oral arguments were presented by the state for a summary judgment and a motion to partially dismiss the case for mootness and a motion to stay the proceedings. And this was based on the fact that they had repealed the state energy policy the legislature had. And they also felt like they needed more time to prepare because of the amendments that they had made to the Montana Environmental Protection Act. The judge denied those motions and for a summary judgment and said the case was going to go to trial. So the trial was this past year, well, I should say, and then from there it went to the Supreme Court, and they denied the state's writ of supervisory control, trying to take it away from Judge Seeley. And it was kind of a final effort to avoid trial. The trial was June 14th to the 23rd in Helena. And then on August 14th of this past year, there was a decision from Judge Seeley. So all during this time, this trial is going on for years. The climate is changing, right? So in 2020, we had one of the driest periods on record. It was a statewide drought. It was extreme drought almost in every sector of the state. We had the largest wildfires in the West at that time, particularly in California, Washington, and Oregon. And the state released a plan, their Montana Climate Solutions Plan in August 2020, which had very reasonable list of ideas for reducing greenhouse gas emissions. And I was on that committee along with about 40 other people. Then in 2021, we had these two other reports released on human health in Montana and diving into an ecosystem to see how climate change affected a particular ecosystem in Montana. And then in 2022, we had major floods in northern Yellowstone due to an unprecedented rain on snow event. which took everyone by complete surprise. And as we moved into the year of the trial, it's the warmest year on record for the planet. And for the first time, the planet has reached a record of 420 parts per million CO2 in the atmosphere. So the trial is going on to look at climate change, and at the same time, the climate is changing. Now, the trial was set up so that we had the youth plaintiffs each talking, and then in between the youth plaintiffs were expert witnesses giving testimony. So here are the youth plaintiffs who I got to know at the trial. They're all amazing people. Ricky Held is from Broadus over in eastern Montana. She was the lead plaintiff. And these are the expert witnesses. And let me just sort of walk through what their testimony was to give you an idea of the real strength of the case. The first person to give testimony was May Nan Ellingson, who, again, many of you probably know. She's an attorney in Missoula and the youngest delegate at the 1972 convention. And basically, she pointed out that Montana was the only state at the time that had a constitutionally enshrined right to a clean and healthful climate. And Montana's climate is currently neither clean nor healthful right now. Then came Dr. Steve Running. He is retired professor at University of Montana, and he was providing the big climate overview. So his testimony talked about how climate is being destabilized by anthropogenic greenhouse gases and their emission into the atmosphere, and that we need to reduce the atmospheric concentration of CO2 to 350 parts per million to stabilize the climate system. And remember, I just told you we're now at 420 parts per million. Then came my part, and that was to focus on Montana and how it was more directly affecting the youth plaintiffs. And so one of the things that I described was how Montana's gotten warmer, and it doesn't matter when you start the clock, it's gotten warmer. And the Montana Climate Assessment, we started the clock at 1950, and it's gotten 2.7 degrees Fahrenheit on average across the state warmer than it was in 1950. And then to point out that snowpack is declining, because that was important to many of the plaintiffs. This is just a look at the Western US as a whole, and the red dots show you where SNOTEL stations where they measure snowpack shows a decline since 1955. And the larger the red dot, the more the decline. In general, snowpack across the West has declined since 1955 by 20 to 80%. I was also able to testify that every ton of fossil fuel emissions contributes to global warming, and that Montana is already experiencing the effects. And then very importantly, that every ton of CO2 that's emitted to the atmosphere increases the exposure of youth plaintiffs to harm now and additional harms in the future. Steve and my testimony was followed then by Dan Faegre, a retired research scientist at the USGS, who was talking about glaciers. He pointed out that Montana's glaciers will be gone in the plaintiff's lifetime. And then Jack Stanford followed. He's retired director at Flathead Lake, and he discussed in his testimony how climate change affects freshwater ecosystems. Then we had medical experts testifying. Dr. Lori Byron, Montana pediatrician, said that climate change induces adverse childhood experiences, and those cause long-term health problems, including things like physical, mental, sexual abuse, substance abuse, neglect, and domestic violence. The plaintiffs, the lawyers also brought in Dr. Lies van Susteren, who's a psychiatrist based in California, and she said children are most exposed and most susceptible to the impacts of climate change more than adults. And they're susceptible both mentally and physically. And that's because they're dependent on adults and their brains and bodies aren't fully developed. The plaintiffs ended with two experts talking about climate issues in Montana more directly. Peter Erickson, who works for the Stockholm Environmental Institute as a climate change policy researcher, he said that Montana's fossil fuel emissions are both nationally and globally significant. And as I'll explain a little bit, he said Montana contributes 166 million tons of CO2 from fossil fuels annually, and that's equal to the contribution from Argentina, the Netherlands, and from Pakistan. And then the final person to testify was Dr. Mark Jacobson from Stanford University. And he made the point that it's technologically and economically feasible to transition Montana off of fossil fuels by 2050. And the primary barrier is really the lack of government direction, that is state government direction, to move energy policy and current government policies. So that's what was covered by the state. And as I said, the decision was released on August 14th, and I'll turn it over to Susan.
Okay, thanks, Cathy. So this trial was really important for many reasons, one of which was it was the first time that climate experts had been subjected to the rigors of trial and cross-examination, even though the state didn't actually mount very much of a cross-examination. It's the first time that a case like this has come to trial, and Cathy and other experts were subjected to having to substantiate their conclusions. So it was a big deal. As Cathy said, the Judge Seeley issued her decision in August, and this is essentially her factual conclusions. The opinion itself is well over 100 pages, but this is basically the argument here. First of all, that human-caused global warming is real, that Montana is a significant contributor to the global warming problem, and that Montana's contributions to climate change are causing harm to the plaintiffs. So that was basically the three key points, which, as Cathy said, the experts had testified to. If we can go to the next slide. This is then the court's legal conclusions. So there were findings of fact and then conclusions of law. So the court's legal conclusions are essentially that the statutory prohibition on considering greenhouse gases in decisions is unconstitutional and therefore unenforceable because it violates the right to a clean and healthful environment, that the state may not comply with that prohibition, and that state agencies actually do have the authority to deny permits when the resulting greenhouse gas emissions would cause unconstitutional harm to the environment. So if you see this, it's important to realize what the court was not concluding. The court was careful not to tell the state how to assess climate impacts or how to include that assessment in its evaluation of permit applications, or how much of an effect on the climate is required to constitute unconstitutional harm to the environment. Because of separation of powers, those questions of how to assess the impacts is left to the executive and the legislative branches. So all the court did was to decide that because of Montana's constitutional protections, the state can't just ignore climate impacts of greenhouse gas emissions in Montana. It's still up to the state agencies to set substantive standards for emissions and figure out how to evaluate their impacts. So looking ahead, I want to talk just briefly about the current Supreme Court appeal. Then I'll talk about what the agencies are doing, briefly about a new work group recently set up by the DEQ, briefly the legislative session, and then Cathy will come back with more climate challenges that need to be considered. So we'll stick on this slide for a minute, Cathy. So the state has appealed the held decision to the Montana Supreme Court. They're in briefing right now. Arguments will be later this spring, maybe early summer, not quite clear yet. And then a decision will come at some point, maybe during the summer. We're not quite sure when that'll happen. If the Montana Supreme Court upholds the decision, then that's going to fundamentally change the conversation about climate change in Montana, because acknowledging climate change then is no longer just an option for the state, but is a constitutional mandate, and the state can't ignore it anymore. If the state does not uphold the decision, then what happens depends on the reason for reversing the lower court. If the Supreme Court finds that there was some kind of procedural error at the lower court, then the case could be sent back to the lower court, perhaps for a new trial. If the decision is reversed because the Supreme Court doesn't agree that the prohibition on considering greenhouse gas emissions violates the Constitution, or if the court decides it's a political question reserved for the legislative and executive branches, not the judicial branch, then the prohibition would be allowed to stand. And then I think the battle against greenhouse gas emissions would then have to focus on influencing policy at the legislature and the governor, the executive branch. For the rest of my discussion, I'm going to assume that the Supreme Court will uphold the held decision, but of course that still remains to be seen. So the case, of course, is about the existential threat of climate change. It is also, though, about various constitutional questions, including what does the right to a clean and healthy environment in Montana's Constitution actually require of state government, and what are the respective roles of our branches of government in determining our climate policy? In other words, that's the separation of powers question. And that's what the state's appeal is mostly about. So if we can go to the next slide, thank you. So the state makes a lot of arguments. This is sort of a rough distillation. There's a lot more detail to their arguments in this, but this is roughly what they're arguing. All of these arguments, by the way, were rejected by the trial court, but that's the nature of an appeal, that an appeal is about arguing that the trial court made a legal error somewhere. So the state is claiming legal error on these matters. So the plaintiffs, so the first argument is that the plaintiffs lack standing. In other words, that they never had a right to bring the suit in the first place because they can't show a direct causal link between the MEPA limitation. And by MEPA limitation, I mean the prohibition on considering greenhouse gases under a Montana Environmental Protection Act review, and the plaintiff's injuries. So what they're arguing is removing the MEPA limitation doesn't require state agencies to consider greenhouse gas emissions. So simply removing the limitation won't do anything to address the plaintiff's claimed injuries. The plaintiff's response is that the Constitution demands consideration of greenhouse gas emissions in permitting decisions, and agencies can't just choose to ignore climate impacts. So removing the MEPA limitation would allow state agencies to consider the greenhouse gas emissions, which is in fact required under the Constitution. The state is also arguing that removing the MEPA limitation won't do anything because the plaintiff's injuries actually come from decades of past greenhouse gas emissions and climate change. So removing the limitation won't address those injuries. The plaintiff's response to that is that the Montana Constitution is forward-looking. You may recall the Constitution requires the state to improve a clean and healthful environment for present and future generations. So we're not looking only at past harm, we're looking at future harm. They're also arguing that Montana contributes a minuscule amount of greenhouse gas emissions. So they're quibbling with the expert testimony, even though at trial the state did not do very much actually well, they really didn't present any of their own evidence that would contradict what the experts had submitted. And so the plaintiff's argument basically is exactly what Cathy said. Every additional ton emitted in Montana adds to plaintiff's injuries now and in the future in Montana. Another argument is that the constitutional provision regarding a clean and healthful environment requires the legislature to implement enacting legislation, and they haven't done that. There is no legislation requiring the state to consider greenhouse gas emissions. The plaintiffs, though, say that the legislature has acted by passing MEPA and other substantive environmental statutes, and that's enough for the court to determine whether those statutes are constitutional, including the MEPA limitation. Another argument is that whether, when, and how to assess greenhouse gas emissions is a policy decision that is left by the Constitution for the legislative and executive branches, not the judicial branch. That the court has no business telling the state what it has to do in this area. And the plaintiff's response here again is this isn't just a policy decision, it's actually required by the Constitution, and it is the court's job to interpret the Constitution. So there's not a separation of powers problem here. And then one last sort of technical procedural argument is that the lower court did not allow the state to do independent medical evaluations of the mental health of the plaintiffs. And the state is arguing that that was a fatal flaw. The plaintiff's response to that, which is also what the district court said, is that the plaintiff's mental health was only at issue to establish that they had suffered injury along with many other injuries, physical, cultural, economic injuries, and they're not seeking compensation for their mental injury, so it was unnecessary for the state independently to assess the level of their mental injury. Besides which, the state had plenty of opportunities that it did not take to depose the plaintiffs and to cross-examine them at trial. So there are other, as I said, more detailed arguments that the state has raised, but this is the gist of it. The plaintiffs have, I would say, strong arguments against each of these arguments. So looking ahead then, I want to talk a little bit more then about the agency rulemaking part here. If the Montana Supreme Court does uphold held, then state agencies will have to consider the impact of greenhouse gas emissions in evaluating fossil fuel projects, which raises multiple questions. One of them is what methodology should be used to quantify the impacts. And again, these are all questions that the court appropriately left to the agencies, because that's the agency's job, is to figure out how to evaluate these impacts. So what methodology should be used? Well, the state did it prior to 2011. Although what they did then is, of course, pretty outdated based on the science we have now. So what the state used to do prior to 2011 may no longer be appropriate. But the good news, Montana doesn't have to make this up from scratch. There are several models around the country and the world, including a model adopted by our federal government and several other states. So there is a model, at least one, and there are several others that Montana could use. Another question is how to evaluate the impact of greenhouse gases emitted by a project. In other words, in evaluating this, should the agency look at local or statewide or regional or national or global impacts? And of course, the level of impact will vary depending on the scope of the analysis. So that's a question the state will have to resolve. Another one is what emissions should the state measure? only direct from any given project, or also indirect emissions. So there's a lot of different ways to measure those. And then another one is, should the state look only at the emissions from a particular project? So a project will apply for a permit, and it's the job of the state to review the impacts of that project and determine whether to allow it to go ahead or not. Now, if you look only at one individual project in Montana, the state might very well conclude pretty much always that one project in Montana contributes only an insignificant amount to global greenhouse gases. And therefore, any one project has no significant impact, and therefore no project would ever be stopped because of an unconstitutional level of greenhouse gas emissions. So that's an issue that is going to come up. Do you look only at the emissions of this one project, or do you look at how much this project is contributing to cumulative effects? So those are all questions. And then another question is whether the DEQ, the Department of Environmental Quality, has the discretion to review greenhouse gas emissions and decide on the methodology, or does it have to go through formal rulemaking with public input, and does it require specific enabling legislation from the legislature? So all of these remain to be questions that will have to be worked out. So in the meantime, until all those questions are settled, I think it's very likely that every time a permit is issued for a fossil fuel project, the state will be sued by one side or the other, always, pretty much. Either because there'll be an argument that the state failed to use an appropriate methodology. Some will argue the methodology undercounts, and some will argue it overcounts impacts. They'll be sued probably for failing to evaluate whether the project will lead to unreasonable harm to the environment. In other words, what is an unreasonable harm? How do you determine what that is? Some will argue that any emissions are unreasonable and therefore unconstitutional. Others will argue that any given project's emissions are so few compared to the global emissions that no project actually really impacts the health of Montanans. So there will be ongoing lawsuits pretty much no matter what the state does. And we're already seeing this in 3 lawsuits that were filed in January by the Montana Environmental Information Center against DEQ for failing to consider greenhouse gas emissions in permits that were given after the held decision. And so there are already 3 of those filed even before the Montana Supreme Court has ruled. And then the Yellowstone Power Generating Station in Laurel is also subject to litigation before the Supreme Court, also about its emissions of greenhouse gases. There's a lot of litigation ongoing, and there's more to come. By the way, in these lawsuits, when a court evaluates an agency's decision making, the court does not get to do its own evaluation. What the court has to do is look at the process used by the agency, and then can only overturn that process if it was arbitrary, capricious, unlawful, or not supported by substantial evidence. So the court doesn't get to say, agency, I don't think you looked at this adequately. We would do it differently. The court has to defer to the agency unless the agency really did something that simply was not supported by the evidence. So of course, litigation is an incredibly inefficient way to make policy. It's costly in time and money, and costly to the environment and our health, but that is likely what we're looking at. In the meantime, the DEQ, if we go to the next slide briefly, has recently formed a work group to study revisions to MEPA. They've been holding public hearings, which you can find. There's a link you can see there at the bottom of the slide. You can watch these hearings. They're open to the public and they're also recorded. One of the subgroups created by this work group has been formed to address climate change. And that group has been meeting about once a month. The most recent one was a couple of weeks ago. They'll be meeting again in the next couple of months. And they've come up with a very long list of challenges, which include the ones that I've just mentioned, but many more than those as well. And they're going to try to figure out recommendations for legislation to the legislature to help figure out the best way to address greenhouse gas emissions in Montana. And then, of course, there's the legislative session. So the next slide, please. Thanks. The legislative session coming up again in 2025. And I think we're likely to see a lot of proposed legislation in response to the held decision. My assumption is that with a Republican-dominated legislature, that the legislature will try to reduce the effect of the held decision as much as possible. We don't know yet exactly how they'll do that, but I think probably any such legislation will probably lead to lawsuits as well. In the meantime, I'm assuming some Democratic legislators and maybe some Republicans too may be coming up with legislation to help implement the held decision. All of this, of course, is in the context of federal law, and there's some movement there as well, although any decision by the federal government on greenhouse gas emissions will probably end up in court too before that can be enforced. So sorry to be kind of a downer about how long this is going to take, but it's how our system works, and it ensures that all voices are heard and policy is made appropriately. So I'll turn it back to Cathy to talk about the climate challenges.
Yeah, thanks. Thanks for that overview. One of the things that has to be done in Montana for any of these projects and has to be considered by the agencies is just what our greenhouse gas inventory is. What are the sources and sinks of greenhouse gases in the state? And I just wanted to call out Peter Erickson's testimony looked at this to some extent. He saw, just looking at fossil fuels, not agriculture, land use, mining, oil and gas, those sorts of things, just looking at fossil fuels, that there were sort of three categories that we're involved in with fossil fuels. One is the fossil fuels that we extract in Montana. So a lot of that is coal, and most of it comes from the coal strip area and is used at coal strip power plant. But there's also oil and gas exports that go out of state, and there's some coal exports that go out of state. When you look at all of that, that's about 70 million metric tons of CO2 when you account for all of that. And not all of it's used in Montana, as I said. So there's the fossil fuels that are consumed in Montana. So that's about 40% of that is the coal from coal strip. But it's also things like the gasoline and diesel that are in vehicles. It's the natural gas that we have in buildings and homes and power plants. And when you look at the fuels consumed in Montana, it's about 28 to 30 million metric tons of CO2 for that category. And then there's the fossil fuels that are transported through or refined in Montana by pipelines. Some of them make a stop in Montana for refining purposes and then go somewhere else. And that's about 80 million metric tons of CO2. So Peter Erickson, looking at the overlap in these categories, because some of the consumption of fossil fuel-based greenhouse, some of the fossil fuel-based sources overlap, came up with the amount of 166 million metric tons. But you can see that it's complicated, and DEQ, for example, is much more interested in the fossil fuels extracted because they're involved in the permitting process, but that other agencies would be involved in the fossil fuels that are consumed or transported. So it's complicated, but it's not impossible, and there's a lot of resources that are available to states and countries to figure this out, to figure out what their actual greenhouse gas inventory is. You know, it starts at the international level. The International Panel on Climate Change in 2006 published guidelines for national inventories, and then that's been updated more recently. EPA has adopted a reporting system that is widely used, and they also have a inventory of greenhouse gas emissions and storage for the US. So states are working with EPA on this. And then there's the Energy Information Administration, which provided lots of the data that were used in Peter Erickson's report, and the International Energy Agency. So just even trying to figure out how much we produce, and then going to the next step of assigning what a cost would be to these different sources is well within our ability to do. And I just want to keep in mind that climate change is continuing, and we need to, you know, get on top of this problem because it's only going to get worse. So these are the most recent projections of temperature change in Montana, looking at an average. The horizontal line is the average temperature from 1981 to 2010. And you can see that by the middle of the century, no matter what global trajectory we're on in terms of greenhouse gas emissions, Montana is going to see about a 5-degree Fahrenheit warming. And then depending very much on what the global trajectory is, it could be anywhere from 12 to 6 degrees warming by the end of the century. Montana is going to get warmer just as part of global warming. And with this warming comes more days of extreme heat, which was something that the youth plaintiffs pointed out, how debilitating that was for them, and also for drought. We're going to see more and more days of over 90 degrees Fahrenheit, and that's responsible for our wildfires, for agricultural losses, for all kinds of health issues. And it's going to happen across the state, no matter what trajectory of warming we're on. This is the more moderate one, the 4.5, and this is the more extreme trajectory of warming, 8.5. This figure comes from the Greater Yellowstone Climate Assessment, and I think it's very applicable for most of Montana. This graph shows plots elevation of snow from 1950 to the end of the century, and blue is the elevation of snow-dominated precipitation, green is the elevation of rain-dominated precipitation, and red, orange, and yellow is the elevation where we get this rain-snow mix, and that's exactly what we've been experiencing in the last day, is this rain-snow mix. In 1950, in Greater Yellowstone, the elevation of snow was down reliably to 7,000 feet. But by the end of the century, simply because it's getting warmer, that elevation is going to rise to 10,000 feet. We are losing our snowpack simply because it's getting warmer and the elevation of snow gets higher and higher. You can see that in the Greater Yellowstone, for example. Here's a map of Greater Yellowstone, and blue is the elevation of snow. So on the left is the elevation of snow in 1990, in 2030 projected, in 2050, in 2070, and by the end of the century. We are losing our snowpack. And this year is typical. We are across the state between 53% and 73% of normal in snowpack. And it's because of the warmer temperatures and changes in patterns of precipitation. So keep that in mind, that this is not a problem going away. It's a problem that's getting worse. It's going to affect the next generation and generations to come. And we need to address it as a state. So with that, we're going to open it up for questions. Thank you very much.
Thank you so much, Cathy and Susan. We really appreciate that. We have, so far we just have one question. So if anyone else has any questions, please feel free to raise your hand and we will call on you. So for this question, any idea how long implementation of all Judge Seeley's findings, assuming the Supreme Court upholds her decision, will take, given the legislative and executive actions required? And in the meantime, will there be any real changes from present state policy?
Well, maybe I'll start with this, Cathy. You can jump in if you have more to add. I would say it depends entirely on our own legislature and our executive branch, what they want to do. They could choose to fight this, or they could choose to work together with many stakeholders to figure out the best approach. I've been watching remotely the DEQ's MIPA work group meetings. Chris Dorrance is the director of DEQ, and he's been an active participant in those. And at the last climate assessment meeting, he said something that I think is exactly right, which is the DEQ does not want to do something that will simply result in lawsuits. They don't have the time and the resources, and nobody wants to just file lawsuits all the time and spend all your time in court. So I think logically, practically, DEQ is very interested in trying to figure out an approach that's not just going to end up in court for everybody all the time. If they're unable to do that, though, then we will end up in court, and then it could take a very long time to work this out. I heard recently a comparison, hoping that this would not be the case, a comparison to Brown versus Board of Education, which of course was a school desegregation case that took decades, and arguably we're still trying to figure out how to resolve that problem that we have historically in this country. So we're hoping that the climate change challenge is not going to lead to decades of litigation. We really don't have time for that. But I think it all really depends on the leadership from our legislature and our executive branch to see how long this will take in Montana.
Great, thank you. If the lawsuit is upheld, are there structures in place or planned to hold accountability?
I can start a little bit with that I think the first issue is going to be, how do you account for greenhouse gas emissions as being the level that's being emitted, and where you're going to draw the line. And as Susan said, there's a lot of thought being given to this, and there's different actions being taken by different states. There's a thing called the social cost of carbon, where $1 is put on a ton of CO2 that's emitted for different projects. It's being adopted federally, and several states are adopting it, and countries too. Canada, Mexico does it to some extent. So once you know what you're doing and how much greenhouse gases are being emitted by different projects, then you're going to have to assign some kind of cost to it, so that you can draw a line and a threshold as to what's going to be something that requires an environmental impact assessment, or what's going to be something that's not. Susan, do you want to take over?
No, I don't think I have anything more to add to that, unless, Heather, we didn't address your question. I'm not sure, Heather, who accountability by whom you were referring to. So if we didn't answer, please give us a more pointed question, and we're happy to try to address it.
Great. Are there any natural offsets to greenhouse gases in Montana?
There are, in the sense that there's forests. Our forests are carbon sinks. And so the question is, how is their capacity to be a carbon sink or carbon storage. How is that going to change with climate change? There's also agriculture, wise practices with agriculture. We can store carbon in the soils, and then just land use in general, more efficient land use to reduce erosion serves as a carbon, a natural offset.
Okay, great, thank you. What can the public do to help in upholding the held decision through the next legislative session and the court litigation?
So I'll jump in on that one. Everything we do, Montana is very strong transparency laws, and so there's a lot of opportunity for public participation. So I think what the public can do is to show up wherever you can. Talk to your legislators, go to the sessions, watch or even participate in these meetings the DEQ is holding, to understand what's happening and to provide public comment wherever you possibly can. I think that's that's where the movement has to happen, I would say, is in the at the moment at the legislative session. And then if the DEQ does engage in rulemaking, in other words, to formally propose a methodology and rules on how to apply it in Montana, then there will be opportunity for public comment there as well. And so I'd say just participate as often and wherever you can.
Thank you. And thank you, Katie, for providing that link to public comment. Do our freshwater
job.
body, oh, sorry.
No, thanks, Katie. That's awesome to put that in there. Thank you.
Do our freshwater bodies serve as carbon sinks as the ocean does?
Yeah, they do to some extent, for sure. The organic material in lakes are storing carbon. Not to the same extent as the ocean. Of course, the ocean is a major carbon sink, and Montana has relatively few lakes. But the large lakes in the world do make a significant difference.
Okay, and then Heather has a follow-up. She says, I was just wondering how the constitutional rights to a clean and healthful environment in the lawsuit could be required going forward. Are there ways to require the legislature to implement policy to actually enforce this? Since we are in essence being told that any accountability comes from policy and the legislature.
Yeah, okay. So this is where lawsuits come in, because under separation of powers, it is the court's job to interpret the Constitution. And so if there's ever a sense that the legislature, the executive branch, is not adequately observing the Constitution, then the recourse is to the courts. And that's why we end up with a lot of litigation. So accountability comes through court review of the constitutionality of the actions of the executive and the legislative branch. The other kind of accountability, I would say, is what I alluded to earlier, which is the legislature is made up of elected people. So who you elect to the legislature matters in this case. So ultimately, I would say the ballot is the accountability that we need to look at the legislative side, and of course at the executive branch as well. We elect our governor as well. So the ballot box may be one of the best strategies here.
Great, thank you. So we are at 1 o'clock, and Cathy, I know that you have another commitment. Susan, you said you could stay on for just a little bit.
I can. Yeah.
Okay. This last
But
question
don't
is
ask me the science questions. Those are for Cathy.
okay. This is a science question. So,
Uh-oh.
yeah. But if you have to hop off, Cathy, no worries, and thank you for your time.
Do you want to read the question?
Sure. Are you or anyone else calculating the exact natural offsets to green gas? And if so, what is the ratio?
So I assume green gas is gas made from biofuels. Is that right? I actually don't know the answer to this question, but I'm sure it's being done because there's so much attention given to biofuels. So I can't really answer your question, but it's a good one.
Okay, thank you. And that is, we're at 1 o'clock and those are all the questions. Thank you so much, Cathy and Dana Cathy and Susan for the informative and engaging presentation. And thank you to everyone who attended and to our wonderful co-sponsors, Climate Smart Missoula, Families for a Livable Climate, and Montana Elders for a Livable Tomorrow. We hope everyone has a wonderful day and thank you for joining us.
Thank you, everybody, and for the good work you're all doing.
Thank you.
And I am happy to stick around if anybody wants to have a further discussion. Thanks, Cathy.
Bye-bye, Susan. Thank you all.
Bye.
Thank you, Cathy.
There's a lot to dislike about Zoom, but it's really awesome that we can be doing this from several hundred miles apart, and Cathy and I from 10 miles apart.
Yes.